Hello, this is Meredith White and Megan Gillis. Today we are going to be talking about birth control rights in a career, titled My Body, My Rights.
First, we are going to be talking about employee rights concerning birth control. Recently, certain employers have been rejecting supplying birth control to their employees through the insurance company. Women commonly use birth control after starting the menstrual cycle, which could possibly be as young as 10. Constitutionally, women of any age can receive birth control even as a minor. Birth control may be taken to prevent pregnancy, ease cramps, and lighten flow of the menstrual cycle. In 2014, Hobby Lobby v. Burwell caused an uproar between large corporations and their employees.
The Supreme Court recently ruled that Hobby Lobby has the right to limit what contraceptives are offered in its employees' healthcare plan. A decision that some people are calling a win for religious rights and others are calling a loss for women's rights. So what is Hobby Lobby and what did the court actually decide? Well, Hobby Lobby is an arts and crafts company based out of Oklahoma City with more than 500 locations around the U.S. It's a privately held corporation owned by devout evangelical Christians. They claim that some contraceptives offered under the Affordable Care Act are against their religious beliefs, and they didn't want to be complicit in providing their employees access to these birth control measures. 5 out of 9 judges on the Supreme Court agreed with Hobby Lobby and ruled in their favor. Still, this ruling is very controversial. According to Justice Ruth Bader Ginsburg, who wrote the dissent to the Supreme Court's decision, there are tons of reasons the court should have decided against Hobby Lobby.
The Hobby Lobby versus Burwell case sparked a concern with the Religious Freedom Restoration Act. This case caused many states to reevaluate the RFRA, which alarmed citizens about their rights. We will look at the history of the RFRA and the other effects it has on the community. Then we will provide our personal reflection and support it with a Harvard Law Review. At the end of the presentation, we will look at Hobby Lobby's side of the case and their reasons behind their belief.
Legally, employers are required to provide birth control to employees if healthcare insurance is provided. This means that birth control would be covered without a copay if insurance were received through a job, a parent, or a spouse. Included in the insurance is the Plan B pill, which is an emergency contraceptive that can be taken within 72 hours after sexual intercourse. The Plan B pill is not an abortion pill. It will not work if you are already pregnant, and it will not harm an existing pregnancy. Recently, certain employers, for example, Hobby Lobby, have fought against this law of supplying birth control, specifically the Plan B pill, to their employees. Hobby Lobby states this is against their religious beliefs and company foundation. After refusing to include birth control in their insurance policy, Hobby Lobby was taken to court by the Secretary of Human and Health Services, Sylvia Burwell, on March 25, 2014. This court case sparked a great amount of controversy throughout the United States due to injustice of their employees and employers.
President Bill Clinton signed the federal version of the Religious Freedom Restoration Act in 1993 when Congress passed it after a controversial Supreme Court decision in 1990. This angered liberals and conservatives, but after Congress passed the RFRA, the Supreme Court ruled it in 1997 that the act could not be applied to states. Now, at least 30 states have their own versions of the RFRA laws as a response to the 1997 Supreme Court decision. During the debate of the Hobby Lobby versus Burwell, 2 justices, Alito and Ginsburg, dominated the opinion. In addition to the Hobby Lobby case, RFRA was in the middle of the dispute in Arizona and New Mexico over rights of the same-sex couples. In February of 2014, Republican politicians decided to pass a state RFRA law that could possibly legalize discrimination against gays by businesses that sold goods and services, but the governor of Arizona vetoed the law after a national debate. The Religious Freedom Restoration Act not only addresses birth control rights, but also LGBT rights.
In our own opinion, we feel that women should be allowed to receive birth control through their insurance provided by their employer. It is unfair for Hobby Lobby to force their views on their employees. The employees should be entitled to insurance that covers all their medical needs because it's the legal requirement. We feel it is important for women to have the option of birth control if they find it necessary for their well-being. By studying and reviewing these sources, we have formed our own opinion on this case of whether Hobby Lobby should be legally required to provide birth control to their employees. In a recent law review written by Alan J. Meese and Nathan B. Oman titled Hobby Lobby, Corporate Law and the Theory of the Firm, we found a great aspect taken from this case. The authors make 3 basic claims in their article. The first is corporate law does not discourage for-profit corporations from advancing religion. Second, such businesses do not undermine the goals of corporate law, nor would it undermine such goals to grant these firms religious exemptions from otherwise neutral laws in appropriate cases. Third, given the plausible reasons for protecting religious exercise by for-profit corporations, there is no reason to reject the most natural reading of RFRA's text, namely, that person includes private corporations of all kinds. These Harvard authors provide an educated outlook of the situation and offer a complete point of view.
To take a different view on the topic, we decided to think of this situation from Hobby Lobby's side. As a corporation that stands for their strong Christian beliefs and conservative company foundations, Hobby Lobby believes they should be able to continue by their principles by not providing such a small part of the insurance policy. One of the biggest questions from a Hobby Lobby point of view is why can the employee not acquire a career at a different employer that will supply the contraceptive? Hobby Lobby has a strong side of beliefs, which is why they won the Supreme Court case 5-4.
By researching the topic of birth control provided by employers, we have discovered a great debate that has opened up a world of religious beliefs. The Religious Freedom Restoration Act also created many questions that allowed citizens to speak up and stand for their own beliefs. We were also able to learn and study a great law review written by Alan J. Meese and Nathan B. Oman. This research project has also allowed us to absorb knowledge in the field of business law.
Thank you for listening to our presentation. Here are some of our resources. Thank you.